My name is Brad Adler. I'm a partner with Freeman, Mathis, and Gary. I'm the chair of our National Labor and Employment Practice section. And with me today is one of my colleagues in our Labor and Employment section, Tim Boughey. And Tim specializes in representing governmental entities. We also have on here Garner, who Carl is a tax partner with Mauldin and Jenkins and knows everything you can know about this type of tax stuff. Tim Evans, also with Mauldin and Jenkins, is going to be joining us as a panelist. Tim is in the Government Advisory and Services team for Mauldin and Jenkins. He has over 20 years experience with the Georgia Department of Labor, so he is an immense resource for Mauldin and Jenkins clients, and he's going to be talking about some Georgia DOL and employment issues today. I first want to say that this webinar today was brought about because of Mauldin and Jenkins' desire to provide as much helpful and practical information as possible to its clients. And so thanks so much for Mauldin and Jenkins for allowing us to participate in your webinar and for interacting and providing information to your clients. We really appreciate it. Along the way, we have met everybody except the panelists, but if folks have questions, there is both a chat feature and a Q&A feature. The Q&A feature will probably be the most helpful. So I don't have to go back and forth, but I know I saw at least one question on the chat feature. We will not be answering questions during the presentation, but at the end, we'll leave 15, 20 minutes to where I'll look at the questions that are asked, and we'll try and address some common issues and questions that are posed by the participants and attendees today. If for whatever reason we don't address a specific question that you have, please feel free to reach out to me, to Tim, to Carl, or to Tim Evans, and we will certainly guide you in the right direction. But our goal today is to try and alleviate some anxiousness, some stress, some concern over these new rules that are coming out, and also just navigating these rules as you're trying to figure out what to do with your workforce. So we initially want to say that we are very, very empathetic to what everybody's going through. It's an incredibly difficult time. We are optimistic that this is just a short little blip, and it will not be as long as people may be talking about, and we're going to come out of this better than we were before, stronger as a community, as a city, as a county, and as a nation, better than we were before. And who knows, this past weekend, I saw more people walking around our neighborhood than I think I've seen in the past 5 years combined. So maybe it'll open up some opportunities that did not previously exist or we have forgotten about. All right, let's jump right in. So the coronavirus, or CV-19, I'll refer to it as either one of those. These are common issues, not just for employers that are 0 to 50 or 5,500. The issues that we're going to talk about are really issues that are very common throughout both industry and size of employer. When we talk about Coronavirus Response Act, that does obviously apply only to a certain segment of employer size, but a lot of these things are going to be questions that everybody's going to wonder about. So the first question, what happens? What do I do if I'm an employer and an employee tests positive for the coronavirus? And we now have a pretty good sense of what everybody should do. And if you have an employee that tests positive for the coronavirus, what you need to do is you need to send that person home. They need to self-quarantine for 14 days after they started exhibiting symptoms, unless a doctor says it's okay for them to come back sooner. And In terms of when symptoms start exhibiting, the scientists believe it's typically about 5 to 7 days after exposure. So by the time someone has exhibited symptoms and then has gotten tested, they probably have been exposed for 5 to 7 days before that. The incubation period is 14 days. So that's how people have come up with 14 days of a self-quarantine after they start exhibiting CV-19 symptoms. Now, you've got an employee who's tested positive. The next step is to say, okay, well, what do we do with the others? And so the first thing you have to try and do is figure out who interacted closely with that employee and what we put as the 7-day period before the symptoms started. And the way that you have to probably do that is first, hopefully you're able to ask the employee himself or herself, who did they interact with? Any particular departments. Also find out, did you eat lunch somewhere? Did you spend a lot of time in a particular area of the building or the facility? Once you have a sense, it's going to be a loose sense, but once you have a sense of who they have closely interacted with, closely being someone who they probably spent more time than just a passing hello and closer than 6 feet, you need to notify those individuals that an employee of your company has either been has tested positive, or in this case, or and we're dealing with an individual who has exhibited symptoms. You got to tell them that, and then you ask them to visit a doctor and get confirmation one way or the other, or to self-quarantine. The key part in this equation is that we can't identify to others the employee who has tested positive. That would violate both their ADA, medical confidentiality rights, as well as implicate some HIPAA things. So that's what if an employee tests positive. So then the next step is, what does an employer do if you have an employee who himself or herself has not tested positive, but a household member has? We want to first make sure that employees know that if that happens, we want the employee to tell us. Because then at that point, if the employee's household member is tested positive, that employee also then needs to be quarantined for 14 days after the household member started exhibiting symptoms. Again, the caveat is if they can get a doctor to certify that it's safe for them to return to work earlier than that, then that's fine. For instance, if they go to a doctor and they somehow get a test and the test comes back negative in 6 days, and at that point they feel fine, then I think it's okay to bring them back. Once again, because now we've got someone who is an employee who has someone in their house who has tested positive, we've got to figure out who is that employee interacted closely with. Once we do that, we're going to notify those same people that they may have been potentially exposed to coronavirus. But again, we're not going to identify the employee who may have spread the virus. What does an employee do? What does an employer do if an employee presents coronavirus symptoms, but they haven't been confirmed? And what I can tell you is there's no perfect answer on this, because some of the symptoms that are associated with the coronavirus are the same symptoms that you and I probably have exhibited numerous times over the last year. I suspect that we all have had a runny nose or a cough or a fever and probably felt a little achy. So what you're trying to do is, when an employee in this season of life right now, in the crisis that we're in, presents symptoms, what we want to do is we really want to take it seriously and be overly cautious. Now, if someone comes to me and says, hey, I have a sore throat, and they don't present any other symptoms, no fever, no coughing, no achiness, then I think you can make a decision if you want to as to what that means. Now, being overly cautious, the smart move is 14-day self-quarantine, and again, unless a doctor certifies that it's not the coronavirus beforehand, it's safe to return to work. But otherwise, being overly cautious, send them home 14 days, figure out who they interacted with, notify those folks of a potential exposure, along the way, you're not going to identify the individual who is presenting the symptoms or has tested positive. What should an employer do if an employee reports that he or she has interacted with somebody who's been diagnosed or exhibited the coronavirus symptoms? And, you know, this is a really tough issue because one of the things that you guys have to do as an employer, and we have to do as an employer, is figure out how far down the branches, or how many branches do we go before we say, I think you're okay. And so when we have an employee that has told us they've interacted with someone who's been diagnosed or exhibited symptoms, I think you have to assess on an individualized basis. One, what type of interaction? Is it the close interaction that really increases the risk that you have been exposed and contracted the virus? Or is it that you walked by each other one time from 7 feet apart and said hello? So we want to assess the type of interaction. And then you want to assess when the interaction took place. Did it take place within seven days of the symptoms exhibiting themselves? Once you have that information, you can then determine whether you believe this employee should be quarantined. If you have somebody who, if you have an employee who has interacted closely and within that 7-day period, and then you probably want to go the route of self-quarantine for 14 days, again, unless a doctor indicates that the person is negative for the coronavirus. Once you determine if that employee interacted closely with somebody and they should be quarantined, then you have to determine, all right, well, who interacted with that employee in the 7-day period? You notify those individuals of a potential exposure, all the time maintaining the confidentiality of the individual who may have it. I see, by the way, there's some questions being asked, and these are a lot of great questions. We're going to address a lot of these, and again, that's why I'm not going to answer them as we go along, because I think we'll address them by the end of the webinar. Next question. Can I require all my employees to get tested for the coronavirus? The answer is yes. That's the legal answer. But as we try to always do, we try to kind of put this into two buckets. There's a legal answer, and then there's a practical reality to how you have to navigate these issues. And so if you have the desire to test all your employees, just to understand that the likelihood that all of your employees will be able to get tested is really minute. The test kits are extremely limited. Doctors are very scrutinous of when they are going to allocate a precious resource on somebody. So you can do it. We just don't think it's practically realistic, so we don't advise it. Can I take the temperature of all employees? This was a little bit of an unknown gray area, but in the last week, the EEOC has come out and said yes. So the answer is yes. Realize, however, that there are some individuals who are asymptomatic, have the virus, but they're asymptomatic, so they may not even test for a fever, but you can do it. So what happens if you want to require an employee who tested positive for CV-19 or exhibited CV-19 symptoms? You want that person to submit an all clear from a doctor before returning to work. Legally, can you do it? Yes. Again, going to the practical reality of side of things, it's going to be really difficult for a doctor to submit that, because in order to do that, they would have to get a confirmation of a test, and that's probably not going to be as likely as we would think, because just the tests are limited, or the test kits are limited. What should an employer do if an employee or the employee's household member returns from an international trip? Well, I've got it. Let's do this. I'm moving some. Has returned from an international trip, but it hasn't exhibited any coronavirus symptoms. This is an easy one. If you have an employee who comes back from overseas, 14-day self-quarantine. Simple as that. If that person wants to go out and try and get confirmation of a negative CV-19 test, fine. But otherwise, you got anybody coming in from outside the United States, 14-day self-quarantine. Can you restrict employees from traveling internationally? If the travel is work-related, yes, you absolutely can. If the travel is not work-related, given the advisory that both the CDC and the State Department have issued, we believe at this point you can do that. The only caveat is there are some states that say an employer can't prevent an employee from doing something that is otherwise lawful. So you have to take that into account. But again, given the current state we are in, a pandemic, we believe that an employer would be entitled in almost all circumstances to prohibit an employee from traveling internationally. Now the question has come up, well, how about domestically? And we think the answer is the same for both internationally and domestically because of the spread of the virus, particularly if you have someone who wants to go to New York or Boston or Seattle. But if that happens, I would encourage you to reach out to the employment council that you deal with just to make sure on the domestic side that there is no state law, we'll call these off-duty lawful activity statutes, that may present a problem. But in the end, what we're trying to do is make sure that employees understand the reasoning of why we don't want them to travel. I think at this point, most folks in America understand the risk, the consequences, and why an employer would not want an employee doing that. So what if an employee refuses to come to work or to travel because of a generalized fear of being exposed to CV-19? You guys are probably getting this a fair amount, that you have an employee comes to you and says, I don't want to come to work. I'm just afraid of exposing myself. Or they may say to you, I live with my aunt or my uncle, I live with my brother or my sister, or I live with my mom or dad or grandpop and grandmom, and they are in a compromised immune state, so I just don't want to come to work. So again, I'm going to tell you legally and practically. So legally, unless something has happened in your workplace, such as you've had a coronavirus positive or you've had a cluster of them, the reality is you can tell them to come to work. And if they don't, you can discipline them. But what we are encouraging folks to do is to assess what's going on individually, what's happening, and try to work with the employee to figure out a solution. I had a client call the other day. The employee lives with his mom lives with him. She is currently going through chemo treatments. So obviously a really, as we would call it, medically fragile individual in terms of the immune system. And he says, I just don't want to risk coming to work, getting the virus potentially, and taking it back to my mom, because if she gets it, she's going to die. And again, the legal answer is you can require him to come to work, but try and figure out a solution that works both for you and the employee. Now, if an employee refuses to come to work that can perform work, your office is open, and they are an exempt individual, you have to pay them if they perform any work in that work week. Any work that should be worked in that week for any day where, must pay for any day where that employee worked in the work week. So in other words, if someone comes in and they're an exempt employee and they work 2 hours and then they leave, you got to pay them for that full day. If that's Monday, you got to pay them for that Monday, but you don't have to pay them for Tuesday, Wednesday, Thursday, Friday if your office is open. Non-exempt employees, easier. You only have to pay them when they work. So if they don't work, you don't have to pay them. So what if an employee wants to wear a respirator or mask at work? Legally at this point, if you said you can't, I think you can do it. But practically speaking, do I think that makes a lot of business sense? Probably not. If someone wants to wear a respirator or mask at work, I think that's probably fine. If you're in the retail space, that's a closer question. Obviously, you've got customers coming in. And so if you don't want customers facing someone who has a mask as they order their sandwich, then, it's okay to demand or instruct the employee not to wear the respirator or the mask. We've had this question a fair amount. Okay, can I send all my employees over 60 or whatever the age is, or all my employees with a compromised immune system, can I send them home? And we just don't think that makes a lot of sense to group people into a particular area and send them home. Now, having said that, that is the answer without regard to the shelter-in-place order that was issued by the state of Georgia, which we're going to talk about in a second. But if you have a stay-in-shelter order, or shelter-in-place, same thing, then you've got to make sure you comply with the terms of that order. And if that order says that, for instance, anybody over 60 can't come to work, well, then you can't violate that order. You've got to decide whether they can telework or whether they're just going to be on an unpaid leave of absence. What if an employee who has a compromised immune system because of a disability does not want to come to work? If you have an employee who has a disability, let's say it's multiple sclerosis, or it's something else that creates, or diabetes potentially, where it creates a compromised immune system, you may have to assess whether you allow them to work at home as a part of a reasonable accommodation to them. And if you have that situation, that's highly fact-specific. You need to get in touch with your employment counsel to go through that issue. Okay, deep breath. We're on to the next slide. What if an employee requests leave to take care of a family member with coronavirus? So a lot of these next questions we're going to talk about, or I'm going to refer to the Coronavirus Response Act, which we're going to get to. But I at least want to remind folks that even if you have somebody who is not covered by the Coronavirus Act because you are over 500 employees or some other reason, it could be that if they are requesting to take care of a family member with coronavirus, that they would fall under the traditional FMLA protocol or framework. Also, at the same time, you've got to make sure that if you are operating in different states, that you're aware of each state's laws. For instance, Georgia has a law that says, essentially, if you provide paid sick leave, then you've got to allow 5 days of that paid sick leave for somebody to take care of a family member. With so many school closures, what do we do if an employee can't come to work because their kids' school is closed or their daycare provider is closed or otherwise unavailable? We're going to tackle the federal part of this through our discussion on the Coronavirus Response Act, but just remember you have to also check state law. Example, New York has a specific statute that says, hey, if you have an employee and they can't come to work because their kid's school is closed because of some public health emergency, then they get leave. Okay, so what do we do now if an employee complains about our company's response to the coronavirus on social media? And I just dealt with this on Friday because this particular client had not shuttered their offices. They were still open. In fact, they weren't even doing any sort of staggered Monday, Wednesday, Friday, Tuesday, Thursday deal. They were absolutely practicing social distancing, and they could do it really well. But one of their employees went onto social media and really wrote a pretty negative post about how their employer didn't care about them because they were still being required to come to work. And the employer called and said, can I fire this person? And what I said is, we don't even need to get into the legal part of this because this would be the worst time to take an action like this. We're in right now a crisis mode where people are super sensitive. So step back. Unless the employee says something that is really detrimental to your business and is patently false, what I would try to do is have a conversation with that employee. Make sure he or she understands the science and understands your business decision. And in some cases, what we can do, and in this case, what happened was this particular client, they can't telework. They need their folks to come in. And so if they have to shutter their doors, what it's going to mean is people are going to lose their jobs. And so what we then were able to do was have a conversation with this employee, explaining the precautions that we were taking, and also explaining that the importance of staying open meant that more people had jobs. How do you avoid discrimination claims in dealing with coronavirus issues? Really simple. Just don't make any judgments based upon the race or national origin of an employee. Do I have to allow employees to telework? The answer is no, you don't. Unless, as we talked about before, the employee has a disability, and one of the things they're requesting is the opportunity to telework because they do not want to risk exposure. At that point, that's such an individualized assessment that I can't really give a broad view. It's just something you're going to have to engage in a dialogue with the employee about. Now, if you do allow employees to telework, does this mean that right after the crisis ends, the employees are going to come back and say, see, I told you I can telework, I want to telework? And I think that's when it's okay to let employees know that, look, extraordinary situations sometimes call for unusual responses and more flexible decisions. And the answer is no, you're not going to allow them to telework after the crisis ends. If you do allow an employee to telework, can you require them to document their activities at home? Absolutely, you can. And in some respects, when someone's at home who has not teleworked before, you probably have to be really clear as to your expectations on their activities throughout the day. If you do not have a remote work policy in place, then I would highly encourage you all to reach out to your employment counsel to get a remote work policy in place. So it is clear, for instance, that your non-exempt employees have to record their time anytime they're performing work. We do not want to walk ourselves into a situation where an employee comes back later and claims that he or she was not paid for hours worked while working at home. When that happens, we want to be able to rely upon this remote work policy that specifically says, if you work it, you got to write it down. All right, so I suspect a lot of you guys are probably here to find out more about the Families First Coronavirus Response Act, what I'm just going to call the Response Act, so I don't have to say the whole thing and confuse everybody if I mess it up. So what is the Act? The Act is a piece of legislation that Congress passed and the President signed into law that provides a varying level of things. But for today's purpose, we're going to talk about the employment components. And there are two components. There is the FMLA Amendment Act, and there's the Emergency Paid Sick Leave Act. So when I'm referring from here on about the FMLA expansion or the FMLA amendment, that's what I'm talking about. If I also refer to the Emergency Paid Sick Leave Act as the EPSL, that's Emergency Paid Sick Leave. For those that know me, they know that I love acronyms, so I can't remember if I have any in here, but if you deal with me a lot, you'll know that I love acronyms. All right, so what does the Act do? One, it establishes two approaches to paid leave for very specific reasons, and it also provides a mechanism where employers can recoup the cost of that leave through credits on the Social Security tax. So let's start with the FMLA Amendment Act. I should say, for those that did not know this, the Department of Labor, U.S. Department of Labor, issued guidance last night interpreting the both the FMLA Amendment Act and the Emergency Paid Sick Leave Act. I don't think it's particularly helpful. It answers a couple of questions that we have been bombarded with, but there are still a lot of questions that people are asking, really prudent, legitimate questions that we just don't have a definitive answer to, which is not unusual because that's what happens when Congress passes a statute very quickly and the agency in charge of interpreting it doesn't have the time to issue regulations. Having said that, let's tell you what we do know. So the FMLA Amendment Act, first, the effective date, April 1st. And that is different than what the Act itself said, because when the DOL issued guidance last night, they changed the effective date from April 2nd to April 1st. The reasoning likely is to match up, so it's on a quarter basis, and they're able to figure out all the quarterly credits better on the Social Security tax, but it is April 1st. It ends on December 31st, 2020. It is not retroactive. So it starts on April 1st. It will end on December 31st, 2020. Eligible employees, anybody who is both a full and part-time employee who's been with you for more than 30 days. We've had lots of questions about exclusions for eligible employees, and the answer is employers of healthcare providers and first responders can exclude their employees from this FMLA Amendment Act. The natural next question is, what is the definition of a healthcare provider? We do not have that answer. It was not in the regulation, and the Department of Labor did not provide us any guidance. So right now we can just operate based on our common sense that it is somebody or an entity that deals directly with patients and providing health care. In terms of so that's the eligible employees. That's who is eligible. So which employers are covered? And the answer is it is employers from 0 to 500 employees. When is that calculated? It's calculated, this was in the guidance last night, in terms of how many employees you have, it's calculated as of the day the leave is taken. Now, we have had questions by clients who have 10 different entities. For instance, franchisees often have separate EINs for each of their locations, or you may have different subsidiaries. Here's what I would tell you. If you have centralized operations, you have one CEO, one CFO, one benefit plan, one HR department, insurance that covers everything, payroll runs from a centralized source, then you're very likely going to be determined to be what we call an integrated employer or a joint employer, and then you can aggregate your employees. What's interesting, though, is in almost every other circumstance, aggregating employers or entities is something the government wants to do because they want to bring an entity or entities within their jurisdiction. So a lot of the statutes say if you have more than 300 employees, you're covered, or 50 employees in the case, for instance, at FMLA. And so they'll aggregate all these entities. Well, here, what's interesting is if you aggregate the employees of all these entities, it actually takes you out of the coverage of the FMLA Amendment Act. Nevertheless, that's what the statute says, and there's no reason to believe that anything else is inconsistent about that calculation. So that's what we're going with. There is a real question about employers with less than 50 employees, because there is language in the statute that essentially says that there is no civil liability for employers for the FMLA Amendment Act. So employers with between 0 and 50 employees are not excluded, but it says there's no civil liability. What we believe that means is that if an employer between 0 and 50 employees wants to comply and then seek the credits, they can, but they would potentially have an argument if they were sued by an employee later on that they are excluded or immune from liability. It does not, however, immunize employers with less than 50 employees from an action by the Department of Labor. So our general advice, I think, at this point is if you have between 0 and 50 employees, you should probably go with the approach of complying and then just seeking reimbursement through the tax credit. All right, So going back, remember, this is one component of the Coronavirus Response Act. This is the FMLA Amendment Act. We've just gone through what the effective date is, who's eligible, which employers are covered. Now what we want to know is, all right, when do you get it? And this is a really easy qualifying reason to understand. An employee gets this leave when the employee can't work or telework because your employee has a kid under the age of 18 whose school or child care provider or place of care is closed or is unavailable because of the coronavirus. In previous iterations of this act, it was a broader definition, but this is the definition that got passed. This is the only reason someone gets coverage under the FMLA Amendment Act. So if someone does qualify for the act, what do they get? And here's what happens. The first 10 days under the Amendment Act are unpaid under this particular act. So this particular act does not demand, require, impose any sort of paid leave in the first 10 days. If an employee wants to use their PTO, or if they want to use what we'll talk about in a second, the emergency paid sick leave that they get during the first 10 days, they can do that. Otherwise, the first 10 days is unpaid. So what happens starting on the 11th day or after 2 weeks? And the answer is for full-time employees, full-time employee gets no less than 2/3 of what their regular rate of pay is for the number of hours that they normally work, not to exceed $200 a day or $10,000 total for that employee. For employees that work part-time and varying schedules or variable schedules, you have to look at essentially the number of hours they worked over a 6-month period, and then you apply the same 2/3 rule and the same caps apply. Does the regular rate of pay that they refer to, does that include overtime? The answer is if you have an employee who typically works 48 hours a week, you're talking about non-exempt employees, and so they're typically getting 8 hours of overtime, then the answer is that the 2/3 of their regular rate of pay would be whatever the 48 hours is, which would include 8 hours of overtime. This right here comes from the DOL guidance last night. It was not identified in the legislation itself. And then finally, what do they get at the end? They get to come back to work. There's an exception if you have less than 25 employees and you can establish that because of the coronavirus, they don't have a job. This is where I usually ask if there's any questions and hands get raised, but as I said before, we're going to tackle these at the end. So let's go to the second component. And just going back, remember, there's two components. We talked about the FMLA Amendment Act. Now we're getting to the Emergency Paid Sick Leave Act. Under this act, same effective date, April 1st, not the 2nd, through December 31st, 2020. It is also not retroactive. Eligible employees, full and part-time employees, but there is no minimum tenure like the other one where you had to be employed for 30 days. And you have the same healthcare provider and first responder exclusion. In terms of who's covered, same thing. Any employer less than 500 employees calculated on the day the employee or the day the leave is taken. We have that same issue of whether there is an exemption for employers with less than 50 employees. The other thing that the statute does do is it does provide that an employer with less than 50 employees can essentially petition the Department of Labor to be excluded because essentially providing the leave would be too much of an undue burden on them. The Department later didn't provide any specific guidance on that. When they issued their FAQs yesterday, they did a question and answer on it, but all it essentially says is if you want to ask the DOL, you can. You shouldn't submit any materials. We think the Department of Labor is probably going to be very flexible on granting those petitions, but who knows how long it would even take. All right, so we know when it's effective. We know who is eligible. We know which employers are covered. Now, once again, what are the reasons that someone gets the EPSL? And there are 6 reasons. I would encourage you guys to keep this on your phone, take a picture or whatever. Take a picture of that reason for FMLA amendment. Take a picture of this right here for the EPSLA. So if you have an employee who is subject to a quarantine or isolation order, and because of that, they are unable to work or telework, then they qualify. If you have an employee who is unable to work or telework because they've been told by a doc that they have to self-quarantine because of coronavirus issues, that person qualifies. If you have an employee who can't work or telework because they're exhibiting symptoms of coronavirus and they're seeking a diagnosis from a doctor, that person is covered. Now, if you'll see, numbers 1, 2, and 3 deal with the employee's own body, something that's happening to their body. 4, 5, and 6 is a catch-all, but 4 and 5 deal with somebody else's body. So an employee is covered by the Emergency Paid Sick Leave Act if they are unable to work or telework because they're caring for an individual who is subject to an order or an advisory that is identified in 1 or 2. And you'll notice the big point here is that it says caring for an individual. It doesn't say mom, dad, sister, brother, sibling, child, aunt, uncle. It says an individual. So what that means is if you have an employee who can't work or telework because they're caring for their best friend, their long-lost uncle, their ex-girlfriend, their current wife, their whoever it is who is subject to either a quarantine or isolation order or been told by a doctor that they need to self-quarantine, then that person is covered. Going to number 5, in number 5, this employee is covered if they're unable to work or telework for the same reason that they would be covered by that FMLA Amendment Act. Their kid's school closed, and so they need to be home with them. And then finally, if you have an employee who is experiencing any other substantially similar condition, in this situation, just reach out. We haven't seen anything really like that yet. All right, so if they do qualify, if they have a qualifying reason, what do they get? Full-time employees, they get a cap of 80 hours of paid sick leave. For part-time, and that's it. It's a cap. However they use it, it's a cap. And it's a cap they have to use before December 31st, 2020. Part-time employees, average hours over a 2-week period. They have varying schedules. You apply the same rationale as you do for the Family and Medical Leave Amendment Act. Now, in terms of how much they're paid, it depends on if they are off work because of 1 or 2 or 3, 4, 5. Or excuse me, 1, 2, or 3, or 4 or 5. So if they are out of work for reasons 1, 2, and 3, then they get paid the regular rate of pay, and it can't exceed $511 a day or $51.10 in the aggregate. If they are on leave because of reasons 4 and 5 or 6, then they get 2/3 of their regular rate of pay, which can exceed $200 a day or $2,000 in the aggregate. You'll see that if they're experiencing an issue with their own body, the cap is higher, $511 versus $200. In terms of substitution of PTO, an employee can first use sick leave under this act before using other PTO. All right? This is not an in lieu of. This is an on top of. So if they otherwise get 2 weeks of PTO, well, now they have 4 weeks. But remember, obviously, under the emergency paid sick leave, there's very, very specific qualifying reasons. You cannot require the employee to use other PTO before using sick leave under this act. Again, if they want to, they can, but you can't require it. You also can't require the employee to find a replacement before using sick leave. The sick leave does not carry over past December 31st of 2020. And in terms of payout, it's whatever your usual rules apply. Certainly in Georgia, but I think in almost every state, California may be the exception, your handbook should say, if we separate your employment, we do not pay you any accrued PTO unless state law requires otherwise. If, however, you leave us, you give 2 weeks 2 weeks notice and you leave us on good terms, comma, we'll think about whether we want to give it to you or not. But your default rule should say we don't give it unless state law requires that we give it. If you look in your handbook and you say we give it, my next question to you is going to be, so if someone sexually harasses somebody else and you fire them, you got to pay them accrued leave on the way out the door. If someone steals money from you or comes in and shoots people in your workplace and you understandably fire them for it, you got to pay them accrued leave on the way out the door. So if you have anything else, please get with your employment counsel and get that changed the next time you update your employee handbook. All right. Of course, we're running a little long, but we're still going to leave plenty of time for questions. But I want to get to these issues. Do you have to pay the employee while they are out for a coronavirus issue? We just went through the first thing you have to decide is, okay, well, do they qualify for one of the acts that we just talked about under the Coronavirus Response Act? If they don't, then here's your answer. If it's a non-exempt employee, as we said before, you only need to pay them when they're working. Now, if the employee wants to use PTO, they can. For an exempt employee, it is a much trickier issue. So if you are going to make a decision not to pay an exempt employee because they're out on an issue related to the coronavirus, you need to reach out to somebody. But the general answer is, if the employer is the person or entity that tells the employee that they have to be out, then you have to pay the employee the entire work week if they perform even a minute in that work week. So if they come in and they spend 20 minutes on the Monday and then you close down and you send them home and they can't telework, you got to pay that exempt employee for the entire work week. If it is the employee who says, I don't want to be exposed, I got to go home, then you only have to pay that employee for the day where they performed any work, just like we talked about before. There are some states that have reporting time laws, which effectively give a minimum amount of time if you have, for instance, a non-exempt employee who shows up and then is sent home. So just be aware of that. Can an employee take PTO while they're out on this crisis? Absolutely. I've had this question probably 5 or 6 times in the last 3 or 4 days. If we are laying off our folks, we're furloughing our folks, which we're going to talk about in a second. And the reason we're furloughing them is because we have no revenue and we can't afford anything. But I have employees who are requesting PTO. Am I permitted to deny that because we don't have the money to pay them? The answer is yes, generally. The one thing you have to do is you have to make available that PTO before, whatever the end of your year is. And if for whatever reason you let them go, then you have to pay out that PTO at that time. In other words, anything that's accrued as PTO is now a vested benefit. You can't take it away from them. You can decide when they take it, but you eventually have to make it available or pay it out. Can we temporarily shut down an office because you have somebody who has been diagnosed? The answer is yes. But really, think about what are the individual circumstances that you're dealing with. I have a client down in Mississippi. It's a 7-person office. They had someone who test positive. That is a really small office. Everybody interacts closely, so the answer is yes. But I also have a client that has 4 floors on a building in Chicago, and one person tested positive on the 14th floor, and they asked, well, do we need to close down the whole thing? I asked, okay, we need to talk with this employee. Did he or she, in this case he, did he ever go to the 14th or the 15th, 16th, or 17th floors? No. Then I don't think you need to do that. It may be that if they interacted with tons of people in the break room somehow, those folks from 15, 16, 17 came down to 14, then maybe you do. The whole point is figure out whether it makes sense based upon the interaction and the type of office and size of office you have. You've got a lot of discretion. If you are going to temporarily shut down an office, you always have to consider whether there is any sort of applicable WARN statute. WARN is the federal statute that essentially says if you lay off a certain number of folks, you have to give notice to both the employee and the state. And states also have what we call mini states have what we call mini WARN statutes. So you have to figure out if you're going to do that, are any of those statutes implicated. We now have a lot of employers that are asking us, hey, can we lay off folks? Can we furlough folks? First thing I want to do is be really clear. A layoff means you are separating employment. It is an extinguishment of the employment relationship. A furlough is when you are keeping them on the payroll, you're just not paying them. It's a mandatory unpaid leave of absence. And the next question you can probably imagine is, okay, what are the pros and cons of each as I'm dealing with a reduced customer demand? My revenues are down 80%, so what do I do? And there's no great answer. It really does depend on the nature of your business and how much cash flow you have, how much cash reserve you have. So this is an individualized assessment. But generally speaking, if you want to lay off somebody, the pros are you're obviously ending the relationship. There's no further ties, and you don't even have to deal with the Coronavirus Response Act application down the road. The cons are you're going to have to give WARN if it's applicable. You're going to have to figure out unemployment. They're very likely going to be eligible. And then you have to assess the soft cost of what's it going to be like when I bring these people back in 4 weeks or 5 weeks. For a furlough, the pros are it is a lot easier to bring your folks back because you're not rehiring them. You're just bringing them back from a leave. So I have one client who has really onerous entry barriers because they are a federal contractor and they have to go through all this testing and clearance. And so they don't want to lay people off because bringing them back will require them to spend a lot of money reentering the workforce. Pros are also if you or if your benefit plan allows it, then you can put people on a furlough, allow them to maintain their insurance. The employer continues to pay his or her, or the employer pays its portion. The employee continues to pay his or her portion. I did have a question this morning. Well, if we want to pay the employee's portion because they're on furlough and they're not making any money and won't have the ability to pay their premium portion, can we? The answer is yes. And I would just communicate with the employee or employees about that. I also think it does have a tendency to increase morale, to create an engagement, to solidify your relationship because the person still is an employee. They can go out and get another job, may need to, but they still have that connection. The downsides of a furlough is you don't really know when they're going to return, or maybe you do, but in this crisis, we don't really know. And it is possible that if you put someone on a furlough and a stay-in-shelter order is issued down the road, then you may have to deal with the question of whether they qualify under the Coronavirus Response Act. All right, I am almost done. Can we lay off employees because of a downturn in business because of coronavirus? Yes, you can. Just have to make sure that you follow any applicable WARN or minimum WARN obligations. You have to make sure you know your unemployment obligations, which we're going to talk about in a second. Tim is regarding Georgia, but you got to do that in every one of the states where you're laying off folks. Can you furlough employees because of a downturn? You absolutely can do it. Again, assess whether there are any WARN obligations and assess whether, because of a reduction in hours, you have unemployment obligations. Can the employment can an employee file for unemployment if hours are reduced? The answer is absolutely they can. In Georgia, Tim's going to talk about how that's going to work because the Georgia DOL just issued emergency rules that impose filing requirements on employers. And then finally, can an employee file for workers' comp if they get coronavirus at work? If they can prove they got the coronavirus at work, then theoretically, I think they probably can file for workers' comp. And if you have an employee who wants to file for workers' comp because they claim they got it at work, then give them the first report of injury, let them file it. It's just going to be, I think, almost impossible for an employee to prove they got it at work versus the 4,000 other places that they went, whether it's the grocery store, the gas station, the sandwich shop, the medical office, whatever it was. So I think it's going to be almost impossible. So we don't see a big, we don't anticipate there's going to be a big uptick in those actual granted claims. And then finally, you're seeing a lot of stay-in-shelter orders that are imposed. And so clients are asking, does that affect my employees' eligibility for expanded FMLA leave? The answer is no. Remember, the expanded FMLA leave deals with one reason. My kid's school is closed, or daycare or child provider is unavailable or closed. Now, does a stay-in-shelter order affect my employee's eligibility for emergency sick leave? If the employee is able to telework under the stay-in-shelter order, then no, it doesn't, because they're still working. If, however, the employee is working at the office and a stay-in-shelter order precludes the employee from working at the office any longer, and they aren't able to telework, and so as a result, they aren't working at all, if it's after April 1st when that happens, then we do think that qualifies for the Emergency Sick Leave Act under Subpart 1. And finally, how do I know if a stay-in-shelter order requires me to shut down my office? You got to read the order. You don't have a stay-in-shelter order from the federal government, but Governor Kemp has issued, it's not a stay-in-shelter order, but it is an order that kind of deals with it. It essentially deals with medically fragile people. The city of Atlanta, if you're there, has issued a far more stringent, almost a true stay-in-shelter order that really does impact businesses. And then you also have counties. For instance, if you're in Cobb County yesterday issued a stay-in-shelter, what some would call a stay-in-shelter order, but it really is not. What it really says is if you are a business, you got to be closed between 6 and 9, except for a few businesses, like a bar, restaurant, you can't have people sit in. But otherwise, it really doesn't impact much. But whatever cities and counties you're in, there's 159 counties in Georgia. You just got to make sure if you have facilities or operations in the county, you got to make sure if that county has issued a stay-in-shelter order. I'm now going to turn it over to Tim Boughey, my colleague. He's going to give some information dealing with government employers in that time period. And after Tim speaks, I'm going to address the questions that are asked. Tim, all yours.
Thank you, Brad. I appreciate everyone for sticking with us on this webinar. I represent primarily government employers around the state of Georgia, and we are in a unique position already because we operate under a different set of rules oftentimes than private sector employers. So I wanted to address some of the questions that I've been getting from local governments around the state. The first is there's some confusion over what is essential. And as Brad has talked about a little bit, when we have these shelter-in-place orders or other closures, a lot of times the orders mention essential businesses. And so the first thing that I think as local governments we need to think about is that we're not actually a business. We're a government entity. And so when everybody else is shutting down, those orders typically do not apply to us in the same way that they would apply to a private sector business. For example, if you're a city, you have a unique charter that usually sets out by the statute that enacted your charter all of the functions that your government is set up to perform for the citizens in the community. Nothing under a shelter-in-place order stops a city government or a county government from fulfilling those essential governmental functions. What we typically have to decide is that when we as a city or a county are going to issue a stay-in-place order or a similar order shutting down businesses or limiting gatherings in our territories, is how do we want to apply that to our own employees? If we're a large government, whether it be a city or a county, we have a lot of functions out there that are essential, and then we have a lot of other functions out there that might not be essential under the definition that's been put out by the federal government, but they are essential under our charters or under state law. So typically what I've suggested is that when we're passing a resolution or an ordinance, we carve out something that talks about how the government is going to remain open and is going to continue performing its functions. And then we can define within that order what we believe is an essential function and what we believe is a discretionary function. For example, if you look at the federal guidelines that are issued by the Department of Homeland Security, law enforcement, public safety, finances, all of those different functions are considered essential. So most employers who are government entities in Georgia are not shutting down law enforcement, are not shutting down waste management, we're not shutting down our fire suppression services, we're not shutting down 911. What I have seen and what a lot of our clients are doing is if the function is something that's performed in an office setting and it's not your police department or your fire department, we are giving department heads the discretion to decide who needs to come into work and who can telework, and then who can be potentially furloughed or work remotely. And all of that is going to be dependent on what your individual needs are. So don't get confused by this debate over whether or not you're an essential business. Because you're a government entity, you're not a business. Now, for example, here in Georgia, we have shelter-in-place orders, and the question comes up, how do we comply with the shelter-in-place orders and deal with our Americans with Disabilities Act obligations? And so one of the first things that Brad has covered this in detail, but what I'm seeing from our clients is you have a lot of police officers, you have a lot of EMS, you have a lot of firefighters and other government employees who are saying, well, I have to go out and interact face-to-face or deal with people by, touching them, arresting them, etc. I have, and I'm above the age of 50, or I have a serious medical condition, a lung condition. And so what we typically have to do is we have to go through the same process that Brad described, which is engaging in an interactive process, finding out what their restrictions are, and then making an individualized assessment as to whether or not we can give them a reasonable accommodation that would continue to allow them to perform their job duties, or if we have to then transition into leave as a potential accommodation. And as Brad mentioned, on April 1st, we have to take into account the fact that if it's something that's related to the coronavirus, or taking care of someone who is suffering from coronavirus or coronavirus-like symptoms, we then have to comply with that new federal law. Now, I also wanted to bring up, because we're getting this from first responders, is what do we have to provide first responders,
Tim,
and what are our options?
Tim, just tell me which slide you want me to be on. Sorry.
Sorry, I'm on the third. I can't see it. I'm on the third slide now.
Okay, got it.
So, the question comes up, what do we have to provide our first responders? Now, as local governments here in Georgia, most of us are exempted from OSHA, the federal statute that governs workplace safety. So what we're typically governed by is Georgia's state law, which basically says that we have to provide a safe workplace. That is a very broad law, and there are no rules or regulations that really govern that. So what the CDC has put out is they recommend that at least our first responders have personal protective equipment, and the list includes a pair of disposable examination gloves and gowns or coveralls. And if we don't have those available, we then should provide someone with disinfectant that they can carry around with them on their duty belt. So think about your police officers who are out there patrolling the streets. They do recommend face protection with the N95 mask or respirators, but if we don't have that, the CDC has said that it recommends finding a suitable alternative, and as everybody is sort of watching around the country, a suitable alternative is a moving definition. And so any type of face protection that we can provide, we should probably be providing that. And the same goes for eye protection. Now, the follow-up to that is that we are not covered necessarily by the CDC's guidelines. They aren't necessarily enforceable. But what I think we need to be doing, and what I've counseled our clients to do, is we need to be building a record that we are trying to provide a safe workplace even for our first responders. And so what we do is you can take, this is copied straight from the CDC's regulations, your police chiefs, your fire chiefs, the people who are department heads for EMS can use this and say, look, we don't have this type of mask, but we are providing this. And if we make note of that, we now have evidence if we are ever sued or face a public backlash to show that we are doing everything we can to protect our first responders. And most of our first responders know that they are called, part of their job duty is to go into dangerous situations, and that they have to interact with people who are infected with all sorts of communicable diseases outside of this coronavirus crisis, but you are going to be dealing with employees who have those types of questions. And the final point that I'll make here that is not on a slide is Brad mentioned discussions on social media by employees. As government employers, we have to remind ourselves that not only do we have to comply with the laws that apply to the private sector, but we also have constitutional considerations. And so with the First Amendment applying to all government employees, we have to be very careful as to whether or not we're going to discipline an employee for making comments on social media. And so for the most part, if someone is broadly commenting on the coronavirus or the national or local response, we aren't going to be able to necessarily discipline that person. The more the social media activity starts to concern our own operations and become attacks on our leadership, we then have to assess that on a case-by-case basis so that we don't run into a First Amendment claim while we're trying to do the best we can during this crisis. And with all that, I will transition now over to Tim Evans, who's going to talk about the Department of Labor regulations.
Thank you, Tim. This is Tim Evans. I am part of the Government Advisory Services practice team at Mauldin and Jenkins, and I've been asked to provide insight that is applicable to both private sector and public sector regarding unemployment insurance. In particular, in the state of Georgia, rules were recently passed as an emergency rule that provided mandating employers file partial claims online for employees who work less than part-time due to a partial or total company shutdown caused by the COVID-19 emergency. Again, this is applicable to full and part-time who are temporarily laid off or whose hours have been temporarily reduced because of lack of work due to COVID-19. Employees must be expected to return to work when the COVID-19 emergency ends. We've already had some questions that have come up, and this does apply to both contributory employers as well as reimbursable employers. The expectation is still the same. I must also say that on our website, and if you'd like to take a picture of the screen that's up right now, that's the direct website for us. Brad, go back one more. Thanks. And as well as my contact information. But on our website, we have a publication that was released on Monday that includes some of these frequently asked questions from the Georgia Department of Labor, as well as a host of other contact information for our contiguous states. So although most of what I'm specifically providing insight on right now deals with the Georgia Department of Labor rules, we do have the access in that communication that was released on Monday, which is available on our website. In the state of Georgia, it does mandate that the employers file this partial claims online, and that's through the employer portal accessed on the GDOL website. These can be entered as single claims or as multi-claims. So there is a provision in there that provides direct instructions on how that can be done, as well as a desk aid. There's also guidance that DOL has issued, or GDOL has issued, regarding what communication they advise you have with those employees that may be impacted or may be eligible for this unemployment insurance. The most important is that the employee themselves do not have to file the unemployment insurance claim. That can be done. That's why the employer is specifically filing it on their behalf. Once that claim is filed, then the employee will receive a letter at their home address that would contain more information and specific how to access it. The employee is not required to report to a DOL Career Center, and for the purposes of this emergency rule, all work search requirements have been waived. In Georgia, that comes up quite regularly, will their DOL account be charged for these benefits? And in the state of Georgia, as long as the employer files electronically on behalf of the employee, then their benefit claims on the partial claims that they submit because of COVID-19 will not be charged to their account, and it would not affect their tax rate. This does vary from other states, and if you have employees in other states, you can contact me and I can help you reach out to appropriate entities to find out that impact. Questions have already come up also related to if an employee is getting PTO or any kind of paid leave, how does that impact their eligibility for unemployment? As employers go into their DOL systems in Georgia or other states, their eligibility is most often and most likely impacted by wages. So it's not a matter of whether it's actual work hours or paid time off. It's impacted most likely by wages that are entered. And that's why employers have to file that information regularly for each weekly earnings. So as I said, if you have any other questions, feel free to reach out to me. And at this point, I'm going to turn it over to Carl Garner, a partner in our firm, to give us a tax update. Thank you.
Thank you, Tim. I'll be real brief, because my part of this presentation is fairly straightforward, and also you can visit our website to get any up-to-date information. But basically, the IRS announced that any income tax returns, income tax payments, or estimated payments that are due on April 15th are now due on July 15th. So this is exactly as it reads. For example, if you have an income tax return that's due on May 15th, it's still due on May 15th. If you have an estimated payment that's due on June 15th, it's still due on June 15th, even though technically it's the second estimated payment. So Georgia did announce this morning that not only did the tax return filing deadline move from April 15th to July 15th, but also that the payments would pretty much follow the IRS. So any income tax payments or estimated payments that are due April 15th for both federal and Georgia are now due July 15th. And we do expect some additional guidance from the IRS on some specific issues around this, and we will post those on our website as they are announced. So I'll take it back to Brad.
Great, thanks so much. just want to go over this briefly. When Congress passed the Coronavirus Response Act, they imposed a requirement for employers to provide paid sick leave or paid leave for the reasons that we discussed. But Congress also essentially said, but we are going to, the government is really going to fund that. And the way that we're going to fund that is we're going to allow you to get reimbursed for the cost that you are, you're paying out on the paid leave program. So we're going to do that through a tax credit against the employer's portion of the Social Security taxes for both the emergency paid sick leave and the sick leave under the FMLA amendment. And you'll just see here on the slide what the credit is capped at, and that's the way they're going to try and get the money back into the employer's hands. The IRS, which if you go to our website, we have issued a guidance under the Coronavirus Task Force blog tab. We've issued a blog on what the IRS and DOL have said on how they're going to try and quickly get the reimbursements back into the employer's hands. Because obviously, if it takes 6 months for an employer to be reimbursed, then it doesn't really help to bridge the gap during what otherwise is a low revenue time. Now, the last thing I want to do is we've gotten a lot of great questions. One of the first questions, actually, it's been asked a bunch, is will you be able to get a copy of the slides? Kelsey, are you on?
I am.
Can you just tell our participants how they can get a copy of the slides?
We're going to use all the email addresses that we used this morning to send out the presentation. The link to the presentation, we'll be able to use that again to send out the slides following this presentation.
Okay, great. All right, so now I want to answer some questions that were asked. I can't answer every single question because there are a lot, but I'm going to try to address common ones. So first, someone asked, all right, well, there's a way that we get reimbursed for what we pay out. What do we need to do to make sure that we are, putting our ducks in a row so we get reimbursed? So one, if you don't have a leave of absence request form where someone is having to specifically fill out the reason for their request, in particular, they're requesting it under the FMLA Amendment Act or they're requesting it under the Emergency Paid Sick Leave Act, then you should get that into place. If there's any question about that, if you don't have that form, you can email me and I will email you that form that you can use, or is it a template? And it also has a template memo that goes with that. I can't promise you I'll be able to send it to you right away today if you send me an email, because I have lots of calls after this, but I will absolutely get it to you in the next 24 hours. But the whole idea is, just like any tax credit or tax deduction that you're going to claim, you want to make sure that you have the documentation in order that allows you to, if asked, establish or prove the details of what you paid out. So in this case, all right, well, when was the person out on the leave? How much did you pay them in compensation that you're now seeking to be reimbursed? Asked, several questions were, how do we determine who an employee closely interact with if we can't identify that person's name to others? It's a really good question. And what you really have to do is you have to go to the person who's gotten the virus or is exhibiting the symptoms, and you really have to go to them and say, who have you interacted with and where? Because you can't go to your employees and say, so Robert's got coronavirus or he's exhibiting symptoms, have you interacted with him? You just can't do it because that is a medical issue, that's a health condition, and you're prohibited from disclosing that to other people. So you have to try and rely upon the employee who has it or is exhibiting symptoms. If that person is in the hospital in the ICU and you can't talk to them, then at that point you try and figure out where have they gone, who have they talked to, maybe even look at their calendar. What appointments do they have or did they have within the time period we discussed? But otherwise, if you can't do that, then you probably have to cast a wider net of those who have to self-quarantine. If an employee wants to identify themselves, that's absolutely fine. So if an employee says, I want to tell people, I give you permission, employer, to use my name. So when you can ask who has interacted closely with me within the last 7 days, it's fine with me. If that happens, no problem at all. I want to at least confirm that in an email or another document so there's no question that the employee gave you the right to disclose that. If the employee wants to tell people, that's absolutely fine as well. We were also asked, can you reduce the pay of exempt employees? Can you reduce the pay of non-exempt employees? We have clients that instead of furloughing or laying off people, they're just reducing everybody by, for instance, half. So with respect to non-exempt employees, simple. You absolutely can do it. The only thing you got to make sure is you stay above minimum wage. That's it. For exempt employees, it's a little trickier, but the long and short of it is that you can go to an employee and say, due to the downturn in business, because of the coronavirus, we've had to reassess and we are reducing your salary from $2,000 to $1,000. What you can't do is you can't fluctuate or vary or change that salary on a week-by-week basis. Well, this week, our demand is down a little bit, so we put you down to 1,000. Oh, actually, but next Monday, things are better. We'll put you back up to 2. Oh, the following Wednesday, things are back down. We're putting you back down to 1. So you're going to have, it can't be a week-by-week variation. It really needs to be, this is where we see, this is where our business is now, and so we're lowering you down. When there is some other specific jump-off point, and you need to increase it or possibly even reduce it again, you can do that, but you've got to be really careful. Otherwise, the Department of Labor considers you to have treated that person like an hourly employee and thus destroyed their exemption. A couple of questions about who determines if an employee can telework or not. Really, this is in the employer's discretion, but if an employee says, I've got a 2-year-old at home, and because their daycare is closed and I have to watch over my 2-year-old, I can't telework, then that's going to govern. It really comes down to having a dialogue with the employee to understand their reasons for why they can't telework. But most of the time, it really does fall within the discretion of the employer to determine if they can do it or not. Several questions about what's the difference between an exempt and non-exempt employee. That would be like a 4-hour webinar in and of itself, but long and short of it is a non-exempt employee is what we would typically consider to be a hourly worker. And an exempt individual is someone who you pay on a predetermined basis that has to be more than $684 a week, and they have to perform exempt duties, things such as they have to manage operations, they have to be involved in the general operations of the business, or maybe they supervise 2 or more people, or they're an outside salesperson, or there's some other exemptions. But that's the difference. Exempt is somebody who's paid on a salary basis and meets the duties test. Non-exempt is hourly. A couple other questions, and if folks need to get off, we certainly understand, but I want to try to get through these for the ones that asked. If you are currently not covered by the FMLA, are you going to be covered by the new FMLA or the Emergency Paid Sick Leave Act? The answer is, if you have 500 employees or less, and in the case of the FMLA, an employee has been with you more than 30 days, then yes, they're going to be covered. For the Emergency Paid Sick Leave Act, there is no minimum time period. If you have between 0 and 500 employees and they are an employee, then they're covered. We also were asked about intermittent leave for both the FMLA and the Paid Sick Leave Act. And yes, an employee can use it on an intermittent basis. But remember, for instance, on the Paid Sick Leave Act, they only get 80 hours. That's it. However they use it, they only get 80. It's a cap. And finally, we did get several questions about what happens if someone is on leave before April 1st and then April 1st kicks in. Can you take an offset into what you've already given the employee? The answer is no. As of April 1st, they get the leave under the FMLAA and the Paid Sick Leave Act. Whatever you have provided before that, you can deduct from your typical PTO bank, but it does not take away from what the Family Medical Leave Act, the Expansion Act, and the EPSL granted. And then two last questions is, if Georgia issues a statewide stay in shelter order, does that implicate the employee or the Emergency Paid Sick Leave Act? It absolutely could. If you have somebody who cannot telework and Georgia issues a statewide stay in shelter order that shuts down your office, and as a result that person can't work, that would implicate subpart 1 of the Employee Paid Sick Leave Act. And then we had a question of, do you have to rehire a person who you lay off? You do not. The idea is that it would be better if you could do that, but you don't have to. And then I've just gotten a couple more questions. Let me just go through these. Hey, Tim, are you there?
Which Tim?
I'm still here.
Sorry, Tim. So, Tim, we've had a couple of questions, Tim Boughey, about are government agencies entitled, or are governmental employees entitled to use the expanded FMLA leave and the emergency paid sick leave?
And the answer to that, based on last night's guidance, is yes. Although it's going to be an individualized assessment based on the type of governmental entity that you are.
Okay, great. Okay, I have an employee that was being tested, and a note from a doctor stated that he is to be out for 14 days, but the test results came back in 4 days. A doctor now says he can return before 14 days are up. Any suggestions? Yeah, I mean, I think if you have an employee who's gotten a negative test, you can bring them back when their otherwise sickly symptoms end. In the same way that before all of this coronavirus presented, if you had an employee who came in, it was coughing and sneezing and said they had the flu, you would say, well, then you need to go home. So you can apply that same rationale now. Let's see. Carl, there's a question of, are the 990s due on May 15th? Are they still due on May 15th?
As of this point, they still are. I do suspect that at some point they will extend that date. In any event, even if they didn't, there certainly would be reasonable cause at this point for filing a late return. So we're still going to try to get out the returns that we have to get out. But like I say, if there's a situation where you can't get the information, then they would waive any penalties with regard to the May 15th deadline.
Okay, great. All right. Well, let's see if there's any other last ones that are collectively kind of in the same groupings. Again, someone asked about the FMLA Amendment Act does not apply to employees who work under an organization with 500 or more employees. Just to be clear, if this is unusual, if you have more than 500 employees, on the date the leave is taken, you're not covered as an employer by the FMLA Amendment Act or the Emergency Sick Paid Leave Act. You do not have to provide it. If you do provide it, you're not going to get a tax credit. You're not covered. In Georgia, can you file for partial unemployment without furloughing employees? I'm not, well, if there's reduced hours, then yes, the new emergency rules, Tim, wouldn't you agree? The new emergency rules impose an obligation on the employer to file it on behalf of the employees if there's a reduced
Yes.
hour schedule, even if they haven't been furloughed?
Most definitely, and they do need to file that as a partial claim and do it online. Otherwise, it may affect their own tax rating if they don't do that proactively.
Got it. All right. Well, I know there's some other questions, but I think we're at 12 o'clock, and I know folks have to go about their days. If there are additional questions, our information, let me go back. Is right here. You can reach out. We can't provide, I will say, if you're not a client, I can give you general advice, but I'm sure people can appreciate that it wouldn't, if you're not a client, it's not protected under the attorney-client privilege. So if it's a very specific question, we may ask you to do that, but we usually can put you in the right place or point you in the right direction. With that, I don't have any other question or any other comments. And Tim and Carl, do you guys have any other comments as we conclude?
No, thank you for coordinating this.
Well, thanks so much again. Kelsey is going to send out the PowerPoint to everybody very soon after this. And, you know, good luck to what is an unusual time. Please let us know how we can help you and support you. And good luck to everybody. Go forth and conquer. Have a great day. Bye-bye.